May it please your lordship. Lordship, in respect of item number 4, lordships, daily discuss.
Admission.
Lordship, I'm praying for moving an IA interlocutory application for reconsideration of an interim order. The lordship may be called for, lordships.
Okay, you filed it
We
already.
had filed it, lordship. The numbering has come, lordship. May I
Be
call it?
brought on recording.
Lordship, I'm so obliged.
Yeah, please, your lordship. Lordship, I'd like to mention item number 20, lordship, 20.
20.
The case diary was called, it has not been received, lordship. I'm on interim.
Not received. Case diary, issue reminder for the case diary. Interim is there. Interim is extended to the next date of list. List 31-3.
The interim is extended. Deeply obliged.
May it please your lordship, I beg to mention item number 8, lordship.
8.
8.
Yeah.
Kindly matter may be adjourned for 2 weeks, lordship.
For 2 weeks. Scan copy has been received. Are you sure? 2 weeks.
2 weeks, lordship.
Land Council 6, a 2 weeks adjournment. Scan copies, however, available. Prayer allowed. List after 2 weeks on. You choose a date. Well, better.
Next week. 26.
26-3. Okay.
Another one prayer, lordship. Item number 12, lordship.
Yeah.
Kindly matter may be adjourned for 2 weeks, lordship.
Same.
Same, lordship.
Okay, what it all. Okay, should I give it on the same day? 26-3. Huh? Okay.
Lordship, I recommend item number 21, let's say. Official was called for lordship.
Official report not yet received, madam. Otherwise, CD is available with us, but official report not.
What will you do? Retain the CD?
No, madam. Product after the CD with official report. Otherwise, he is in time.
Yeah, I am on interim.
Case diary is received, but without the FSL report. The learned additional PP submits that the case diary can be sent back and returned back with the FSL. Prayer is allowed. Interim bill stands extended till the next date of listing. List on 31.
7th of April, madam.
7th of April.
Deeply obliged.
May I be listenership? I get to mention item number 24.
24. Tell me,
Withdraw mine.
you want to withdraw? Your good name, please.
A. Mandal.
Mr. A. Mondal, Learned Counsel, for the petitioner submits that he has instructions to withdraw this bill application. The prayer is allowed. The AB is disposed of upon withdrawal.
Item number 1.
Please, your lordship. Your lordship, CD is received maybe with item number 18 and 19.
It's connected.
Yes, you may know. PS case number.
Take it up.
17, 18. Madam, at the time of.
At the time of 18, 19, we'll take. Okay.
Please, madam.
Oh, wait, 18, 19.
Item number 2.
Yeah, please, your lordship. Lordship, PRS bail application, lordship. FIR is at page 10, lordship, type copy, madam. Allegation, mallet, is there that petitioner along with mallet, other person stopped the vehicle of the informant, demanded money and assaulted one person. Lordship, as per the FIR, my lord, there are altogether 5 accused persons named in the FIR. I am for the accused number 1. This Babu Ali, son of Tutamia. The actual background of the case, my lord, arises out of a my lord, business-related monetary dispute between the informant and the petitioner. My lord, the petitioner running an engine boot in the Brahmaputra River, and my lord, the informant is a cattle trader who frequently my lord, travel with his cattle, my lord, from this Gorimari of Soigauria to Bagbor market, my lord, and my lord, the business. There is a business dealing with the petitioner, my lord, relating to the transportation of this cattle through his boatman. Well, in course of such business, my lord, a sum of rupees 25,000 is remained due from the my lord from the informant to the petitioner. On several occasions, the petitioner approached to pay, but the informant avoided, my lord. On the alleged date, my lord, when the petitioner proceeding towards my lord the river guard, they meet in the early morning. and the petitioner asks the informant to pay the dues, my lord. Admittedly, my lord, during this conversation, my lord, a quarrel took place, my lord. But my lord, informant, just to harass the petitioner deliberately, my lord, the informant and other family member, the petitioner and other family member, my lord, just to harass, converted this incident into a criminal case, my lord.
Have you stated this?
Yes.
Story?
Para number 6.
As per the FIR, one got injured, my lord,
Yes.
in hand, my lord, seriously injured.
That's what.
So, my lord, is there in medical
Actual
report?
case.
Malad, moreover, Malad, one co-accused, my lord, granted bail by the district and session judge at page number 22. Page number S20, my lord. Learned trial court granted bail by considering the nature of allegation.
Just a
and
minute, just a minute. I'm reading your paragraph 6.
Yes.
Okay, yes. Which order?
Page number 22, relevant person.
22.
22.
Hmm.
Second paragraph. Lord. Considering the nature of allegations made and materials on record, including the statement of witness and advanced stage of the investigation of the case, the court is of the opinion, considered opinion that this is a fit case where the benefit of bail can be extended to the co-accused Abdul Salam. One co-accused has granted bail considering the advanced stage of investigation. In this case, the investigation may substantially progress, my lord. And my lord, petitioner is a local person and will fully cooperate with the investigation. At this stage, I pray some interim protection may be.
Your good name, please.
And Jamal.
There it will be necessary, but anyway. Heard Mr. A. Zaman and learned additional baby for the state invoking 482 BNSS. The petitioner, only one here,
Only one.
one petitioner is seeking anticipatory bail in connection with Goroimari PS case number 94 of 2025 under so section. The case arose out of an Ezahar dated 21/10/2025, lodged by Sakat Ali, naming 5 accused persons and unnamed others. First, the gist of the allegations is that on 11/10/2025, in the early hours, he was going towards Jambari with 6 cattle in his vehicle, and whereupon the accused persons blocked the road and demanded rupees 1 lakh, and he paid rupees 1,000. But for the remaining, they attacked him, and one Sukur Ali was inflicted cut injuries on his hand, resulting in bleeding and injuries. Was inflicted cut injuries on his hand. Full stop. The learned counsel for the petitioner has drawn attention to para 6 of the bail petition. He stated and submitted that the petitioner, petitioner's father and his
father has.
petitioner and his father are running a business of engine boat in Brahmaputra River for transportation of goods, and had a business transaction with the informant, during which money was due, and on the day of the incident, he had gone to ask for the money, whereupon there was some minor quarrel. However, the informant exaggerated the incident and lodged the incident FIR. It is stated that no incident of assault or attempt to kill as alleged or extortion has taken place. The learned counsel also draws attention of this court to an order dated 29/11/25 passed by the learned session judge Kamrup Amingaon, wherein it is mentioned that the investigation is at an advanced stage. Nevertheless, call for the case diary from the concerned police station. However, to enable the petitioner to record his statement, it is directed that in the event of his arrest in connection with this case, 30,000 with one security. Satisfaction of arresting authority, subject to the condition that he will cooperate, appear before IO for examination, not hamper or tamper with evidence, and not commit any illegal activities or offences. List the matter on 6th of April.
Much of.
Item number 3A.
With legal losses. This is 482 petition matter. Fire is losses can be perused and expiration. This is a search-sheeted case, my lord, and I have shown as a absconder, my lord.
Nice.
Page 9.
Page 9 is the FIR.
FI. Translated copy.
The main allegation is against accused number 1.
Accused number 1. My lord, others accused are already been on bail, my lord. And incident took place, my lord, 23/5/2022. They have filed FIR 28/6/2022, but did not mention why they have been filed FIR late, my lord. And my lord, there is a compromise petition also, my lord. That is, I won't be able to annex, of course, because it is already been submitted before the law court below. Parathing, my lord.
Because it's of nature of the case, the police did not accept, right? It was not accepted by the police. Police
Yes,
did not
yes.
accept it. What do you say?
Lord, I may be good to
Already
appear before the office, official in charge to.
No, now already succeeded. Appear before the court, the officer in charge, now.
But 376 magistrate will be able to grant. No, I have doubt. It's punishable up to life. It's punishable up to life. Also. But it is trial has not started, right? Trial is not started.
Whether committed or not.
Right, no. Not an I know. I may be protected, my lord.
Should we ask them to appear
Yes.
some protection and call for the scan copy or dispose it of completely? Yeah, then you have, if we have to see on merits.
But merits also, it's tried, actual incident. Actual incident of rape is not there, is tried. So, attempted to rape.
Or dispose it of them. Dispose it of them. The Devi counsel for the petitioner and additional public prosecutor. Full stop. Invoking 483 BNSS, 482 BNSS, the petitioner so and so is seeking anticipatory bail in connection with Golokgon's PS case number 219 of 2022 under section so and so. The corresponding GR is GR number 1112 of 2022 and stated to be pending before the court of the learned CJM Dhubri, learned CJM Dhubri. Full stop. It is submitted that the allegation in the FIR dated 28/6/2022 is that accused number 1 mentioned in the FIR, who is the present petition, entered the house of the victim and tried to sexually abuse her. The other persons, the allegation against the other FIR named person is that they threatened the victim side if the matter is reported. But there might be some concern to the victim side actually. That problem is there. The relevant copies of the charge sheet have already been annexed Full stop. It is drawing attention to para, what was the para? This para 10 of the bail petition. It is submitted that compromise was worked out between the parties at the behest of villagers, and but the compromise agreement was not accepted by the police at Sagolia Gate Police Station. Needless to say that one of the present penal provisions was 376 IPC, which is non-compatible. It is also stated in the para 10 that other co-accused are already on bail. Full stop. Full stop. The FIR was lost in 2022 itself, and on completion of investigation, the charge sheet was submitted in 2022 on 30/10/2022. So long, its trial has not started.
Not started.
Not started. It is submitted that trial has not yet started. Full stop. In the circumstances and on the basis of materials, if the court is inclined to grant bail to the petitioner, subject, however, to suitable conditions to address any concerns pertaining to the victim side. Therefore, it is directed that in the event of his arrest in connection with this case, it shall be allowed to go on bail of 50,000 with one security, subject to the satisfaction of the arresting authority. However, he shall appear before the learned court below and submit bail bonds, and on which necessary orders shall be passed by the learned court below. The following conditions are imposed. Number one, he shall be available for trial if one commences. He shall not hamper or tamper with evidence. He shall not in any manner intimidate or harass or harm the victim or informant or their family members. He shall not intimidate or try to influence any witnesses. Violation of the bail conditions would entail cancellation of bail. Bail petition stands allowed in this post. I think it's almost time.
Bail hearing after bail hearing PA 5.
Amicus is there. Now or after lunch?
After lunch.
Please come. We'll finish it, no problem. Could you see the scan copy? Then there is no problem. Nimish may be informed. Mahajan is fine. No,
Item number 5.
I will not say no.
May I please process? In this case, my lord, already charge sheet has been submitted, my lord, and trial is going on, my lord. Already,
Trial is good.
PW, yes, my lord. PW1 is already examined, but my lord, her cross examination has been reserved, my lord.
PW1 is the victim.
Examined, my lord.
Is the victim.
Yes, my lord.
But cross is not complete.
Cross is not complete. My lord, already, my lord, 204 days, my lord. 204 days, my lord. My lord, as the charge sheet has been submitted, my lord, but just, my lord, his, my lord, appearance to be ascertained, my lord.
Okay.
And on any condition, my lord, your
Just
lordship, yes, my lord. On any condition, my lord.
Small handwriting. It's have you seen the 164 statement? What she is? How
She was taken and in my lord vehicle the track.
how old is she? 40.
We are ready to the middle.
Heroin. This is commercial quantity.
Commercial quantity.
Only one thing your lordship may kindly note that here lordship they said on the place of occurrence their source was there. Two persons, that is Fazul Haq and Anal Chakraborty, they were also there, present there. But in spite of that, in the FIR lordship, no person's name is there as miscreant. Because subsequently they say that this source and this person had identified the accused. So if they have identified the accused, they could have mentioned their name in the FIR itself. Because FIR was lodged after 12 hours of the incident lordship. That in the form itself, your lordship will find that.
The accused persons are not named in the FIR.
Lordship,
Not
not
named.
named.
But in November 2025, there will be no justification to not comply with the notice. That will be very unfortunate in this kind of cases. Anyway, let us proceed. Now,
So my
notice-
first ground is that lordship that initially they did not.
grounds are there. 47 grounds are there.
No, lordship may kindly say 40 in 47, what they have said, they have mentioned the section as 21A. 21A is bailable offence. So in NDPS cases, that quantity and that sections, they decide whether it is bailable or non-bailable lordship. And in the grounds lordship, they have not mentioned any quantity lordship to determine whether it is bailable or non-bailable. That is not there.
It is in Bengali also. They have there.
Yes, in Bengali now, lordship may kindly say in Bengali, page 22. Page 22, lordship, I am referring to section 47 notice. Page 22, ground number 5, lordship. In Bengali, lordship may kindly see what is there, lordship. He is relative of one of the person who went to the place of occurrence. That is what it is written in
Anyway,
Bengali.
nominated person. Anyway, so let us, this is one aspect.
This is one.
Another aspect is CD has come.
Madam,
Investigation is going on.
investigation is going on because one of the accused himself said that there are some other persons. He is doing his business since long. He went to supply this to some other persons. At that point of time, when police seeing the he fled away, leaving that way. Subsequently, he was arrested. Subsequently. Now, fact is that regarding 47, 48, these are all complied. These are all complied. Details has been given, reasons given, and FSA also has come. This investigation is there at the verge of completion.
I see.
FSA also heroin is proof.
On 36 also, I have submitted that.
You mentioned about because
36,
Page
36
28.
actually he was caught.
36.
Suddenly he was caught, right?
No, he was subsequently arrested.
He was subsequently arrested.
Subsequently.
So in this case, in this kind of cases, notices would not be practicable, but they have to state the grounds.
36.
The forwarding. Can I have?
Forwarding,
Can I-
forwarding grounds are there, 47, 48, 36,
36 page 28, your lordship will get lordship, no signature of witnesses.
এখন দিব স্যার
Every bit of detail they have to pay attention to, the investigating agency.
And your lordship has also discussed about 47, 40, relevance of 47, 40.
I think the 47, 48 notices are all right, in my opinion. They are all right, I think. Cannot take a very, very hyper technical view, but broadly they are all right, I think. In bilingual also, that is okay, but as far as this is concerned, where is the 36 notice?
Page 20.
Have you attached?
I have not played back after the 47, then 48, then 36
Page 28 of my petition, additional petition.
Page
28.
additional affidavit. Can you cross-check the arrest memo on the case diary? Is the case diary? Can you cross-check it once? Why they're not taking this care? No, this is basic thing. You know, they know, of course, police people should. They know. It's not that they don't know. They don't. They should.
The copy which is, which I have annexed is the certified copy now.
Oh, that's okay. This must be the one. It's similar to this order. It's a serious case. You know. Yeah, Amit. Additional property procedure. Invoking 483 BNSS. The petitioner is seeking regular bail in connection with Sri Bhumi PS case number 497 of 2025, registered under section 21C 29 of the NDPS Act. Full stop. When so much, nothing.
Arrest witness is not there.
Witness is not there. And arrestee signature is there. Arrest.
There witness signature is not. Otherwise, regarding 47, 48, malab, those are compliant.
Who have signed on the arrest memo? The accused is signed. Arrestee is signed and
And the
IO is signed. This thing, see, the thing is that when the grounds of arrest under 47, 48 has been narrated so nicely in two languages, not taking any signature of witness on the arrest memo will, the IO should not blame if somebody takes a wrong conclusion that it was done intentionally.
If they have served the 48 notice to the relatives, they could have taken signature.
No, sir, it can be a respectable person, any person.
Any person, yes,
Necessary.
that is
Because
what I'm saying.
At the time of arrest, relative may not be available. So
But in my case, they have shown that it is the place of occurrence, it was served
they could have.
at the police station.
They could have easily, who will refuse? They will agree. Any PS Act, also. The petitioner was arrested on 27/11/2025. As per the allegation in the FIR, information was received regarding dealing of narcotics near a place near one Baba Hotel bypass. Accordingly, GD number 3 dated 23/11/25 was made and search operation was continued.
Entry number 5.
During the search of while the police party was going in the vehicle and reached the spot, one person was found carrying a bag, and upon seeing the police, he fled away. Full stop. Thereafter, the abandoned bag was searched and 359 grams of suspected heroin was found. Full stop. Mr. Ahmed, Learned Counsel submits that no persons have been named in the FIR, though the names of witnesses have been mentioned. So he also contains that notices under 47/48 BNSS have not been complied. The third contention of the Learned Counsel is that the arrest memo in terms of section 36 subsection 2 BNSS, right? 36 subsection does not bear the signature of any witnesses. Full stop. The case diary has been received, which indicates that investigation is not yet completed. Full stop. I have carefully, considering the quantity in question and the penal provisions given, the rigors, the applicability of section 37 of the NDPS Act has to be seen. Full stop. However, as contention has been made regarding non-compliance with notices, first, that aspect has to be seen. I have carefully perused the notices under 47, 48. Stop. The notices the notices have been given bilingually in English and Bengali. And upon perusing the contents, I find that the grounds of arrest indicated are sufficient. Therefore, the said contention is not accepted. However, upon perusing the learned additional PP fairly submits that the arrest memo has been signed by the IO and the arrestee, and it does not bear the signature of any witnesses. From the case diary, I have perused the said notice and find the contention in this regard by the learned counsel as well as the learned additional PP to be correct. Let me to go back to this. The learned counsel for the petitioner has placed an order dated 26/11/25 passed by this court in BA 3373 of 2025, where in similar circumstances of compliance with 47/48 BNSS, but non-compliance with 36/2 BNSS dash bail was given after referring to the principles in DK Basu was State of West Bengal, AIR 1997, SC 610. Before proceeding further, section 36. Section 36 of BNSS may be reproduced herein below. Thus, it is clearly indicated that the memorandum of arrest has to be attested by at least one witness. These requirements also follow from the constitutional provisions pertaining to liberty incorporated in Article 21 incorporated inter alia in Article 21 and 22(1) of the Constitution of India, as has also been held in DK Basu Supra in paragraph 38, which may be reproduced here in bill. We are familiar. Consequently, despite the serious nature of the alleged offences, the applicability, the per se applicability of section 37 per se, the notices under 47/48 BNSS also being found in order test. However, due to the infirmity in the notice under section 36 BNSS and its linkage with constitutional provisions as mandated in DK Basu, this I'm of the considered view that like in the order passed in BA 3373 of 25, bail is also required to be given in the instant case. Full stop. accordingly to same conditions. Same conditions. Return back the case diary, full stop. Next paragraph. It is necessary to observe that in all cases, arrest of a person should be made only if it is really necessary. Nevertheless, where in serious offences where arrests are genuinely needed, the procedural aspect of arrest has to be properly compliant by the IO, including the aspect of notices under section 36, 47, 48 BNSS. With regard to these notices, the IO is expected to be aware of the latest position of law in this regard. And as far as notices under 47, 48 BNSS, I do not like aware of this full stop. In serious cases where arrest is genuinely needed for the purpose of effective investigation, the IO has to take steps to ensure that such arrests do not become fatally infirm due to procedural infirmities. Next page. A copy of this bail order shall be sent to the learned Superintendent of Police Tribunal for kind perusal. The bail petition stands disposed of. Return CD. Okay.
With the satisfaction of special just.
Special just review.
And one more aspect, Lordship has raised that 36 to 36B2, Lordship, that may be
36B2.
B2.
Yes.
Small b.
Small b, yes,
Small.
that's the thing. Small b2. Small b, Roman 2.
Roman.
Huh? Small b, Roman small 2.
Roman 2. Obliged.
Item number 9.
9 my lord, as per office note 10/3/26 service report is awaited.
If you have been received,
POCSO matter. Service report is awaited.
17, so that they can pay instruction whether.
They can. Service report with regard to the informant / respond number 2 is stated to be awaited. The prosecution said take instructions regarding such service.
On 17,
Scan record is available.
on
17.3. Okay.
Oh, pleasure.
Item number 10.
Yeah, Mr. Jalan.
10 years, well, for allegation is under the POCSO, the under trial prisoner, but the office note says that the service report has not been sent back.
Not received. Same order.
May it come up 18 minors.
Same order. Khali, it's
Can I
on-
obtain the
Yes, scan record is available on 18.
Most of it.
Event.
The POCSO matter, notice was issued to the respondent as per the service report.
Yes.
May I please, Your Lordship?
You have appeared for the informant.
For the informant, Your Lordship, respondent to today we have filed a fresh wakalatnama, Your Lordship.
Okay. So you'll need a copy.
Yes,
You have you received a copy?
Yes, Your Lordship, we have received the
received a
copy, the Excel.
So we proceed with the case.
yes.
The matter may be kindly be timely, because my lord, in the my lord, that is my lord, the office note, it is reflected that my lord, nobody is engaged.
Hmm.
So we thought that my lord, maybe my lord, after getting the instruction, my lord, amicus may be appointed. Now as our license stand is appearing, maybe timely, in the meantime, I will go through the PCR.
Okay. Or
Today itself, my lord, I can.
Today-
Yeah, as because he is ready, my lord, informant is ready, I have no, my lord, problem.
after a little while.
Then.
Right, please, Your Lordship. POCSO matter, Lordship, petitioner behind the bar attempted 137 days, Your Lordship. And this is subsidiary matter and this can copy was called for this, is received, Lordship.
Scan copy is available.
Or in the 13.
That is also awaited, my lord.
Probably taken a step, Lordship. So CL as well as spokesperson.
That they can do. Service to awaited.
Then
Service
18
report is
lawsuit.
awaited. They'll take instructions.
Then 18 lawsuit.
Scan report is scan TCR is available. Pardon?
18 lawsuit.
18.
Mashallah.
May
Yes.
your lordship, 483 bail application lodged. Your lordship, this is the shown, your lordship petitioner got shown arrested lordship.
Acha.
So apart from the merit of the case lordship, there are two violation with regard to the statutory compliance as 36(2) as well as 35(3) lordship, because this offense involves here at 316, that is criminal breach of trust. Earlier it was 406 RPC and 318, that is cheating lordship. Now lordship,
What is the allegation? The diary has come.
allegation basically petitioner is not named in the FIR lordship. May I take your lordship to the contents, page 14 lordship. May I read the contents lordship?
Yeah.
With due respect, I Deputy Deka so-and-so of military area, Narangi so-and-so, Gauhati, would like to state that I am registered owner of Mahindra so-and-so, registration number so-and-so. I, along with other vehicle, namely so-and-so, have handed over vehicle to one Rupjyoti Das, son of so-and-so, on monthly rental basis. That for last 1 week, we are unable to trace Rupjyoti Das as his phone number are switch off these numbers. When we have visited his residence, his house was locked and no person was there at his house.
GPS location is found in,
Yes.
okay.
Then, yes, ma'am. Now, lordship, pursuant to this affair, the here petitioner was not named, and the lordship, pursuant to this affair, lordship, all the vehicles mentioned in the affairs has already been recovered. That should be there, lordship. I have also obtained the certified copies, which will reveal that these vehicles
Vehicle has been recovered.
recovered.
Only one vehicle, right?
No, 3 vehicles has been recovered.
Mahindra,
It
Maruti
was-
Fonks,
It was placed.
Mahindra
on-
Scorpio,
Yes, it was placed for the rental basis on some.
I-10.
Yes.
Okay, 3
So
vehicles.
it's recovered.
Oh.
But when petitioners spent 27 days, meanwhile, lordship, there is a violation of 36(2) and as well as 35(3), because this comes under lordship, Supreme, I have mentioned at para number.
Up to 7 years.
Yes,
So
lordship,
it comes
is
under that.
mandatory. Mandatory lordship. Notice has to be served.
No, notices, as I understand it, it is, they have to give justification.
Yes.
My lord, here main culprit is Rupjyoti.
Hmm?
Main culprit is one Rupjyoti.
He was arrested.
He also arrested, my lord. Now petitioner, my lord, took vehicles from the different persons, my lord, and he supplied 8 numbers of vehicles to that Rupjyoti.
Lordship, here, lordship, I have.
Acha,
made-
he's not named in FIR.
No,
Later he was arrested.
Lordship, I have to add one more part.
Yes, please, go ahead.
This Rupjyoti lordship, I have come across with Rupjyoti lordship. I have a HRA trading company. I have annexed all documents here, lordship, with this application. And he was in regular visiting terms in my office. So even I have handed over my sisters, my brothers' vehicle on
Gotcha.
rental basis to Rupjyoti. Even I can say that Rupjyoti has duped the petitioner also. That is also the case, lordship. I have, by my own filed FIR before the Hatika police, and after my FIR only Rupjyoti got arrested, lordship.
I see.
I made the statement here. Now, lordship, here basically I'm on 3 count, lordship. Firstly, lordship, I have spent already 27 days in the custody. Since from 5 to it's 40 days, more than 40 days, because I'm soon arrested in this case. And lordship, the vehicle in question mentioned in the affair has already been recovered, lordship, and there is non-compliance of the statutory provision 36 as well as 35(3), lordship.
Should I see the case diary?
And the non-compliance of the arrest memo and all this, these are compliant, 47, 48, all are compliant.
36.
36 compliant, this arrest memo, may kindly see the arrest memo, here are signature of the relative.
What are the materials against him?
Materials are, he, yes, one thing is correct, that he gives 8 numbers of vehicle to Rupjyoti. And Rupjyoti subsequently sent them to Arunachal Pradesh, some vehicles sold, and all vehicles not yet recovered.
According to
one vehicle
learned counsel's submission, madam submission, that he has given his sisters.
Sisters and brothers also.
That aspect is there. That is our
instruction.
instruction.
As per the statement of the accused also, but he, the Rupjyoti has done this. That
He is not involved, according to him. According to him.
But there is just arrest memo and his statement.
That is secondary, yes, but my contention basically, since vehicles been recovered and considering the length of the detention, Lordship, local person.
Suppose he is involved in a big racket, then that even the length of detention. Otherwise, we can consider on there.
Statement of the in the hospital and arrest memo.
This is okay, I think, grounds of arrest.
Yes, the grounds of arrest is 36, arrest memo also.
That's why, now it will be very surprised if they don't follow, no? See. This person Dipen Sharma's form, it was taken in name.
Yes, in the name of Dipen Sharma is the petition.
What are the direct materials against him, except for this?
The vehicle, he contacted persons, other persons, and he took the vehicle on rent agreement and supplied to that Rupjyoti.
And
So
Rupjyoti ran away with the.
a part of the record, ultimately.
No, maybe, may not be also. Suppose
If
he has, to his own relatives also, he has given the vehicles. That aspect is there.
Yes,
The case diary. Not there. In his statement, own statement, not there.
no, his statement is not there.
He's wanted in case, connection with another case.
Yeah,
He is shown arrested in this case.
In this case.
Yes, Lord.
wanted in another-
Thereafter, he is shown arrested in the,
Nunmati 21 of 2026. Earlier in that case, he was arrested, subsequently in the.
he was arrested in this case, Lord.
There are some materials against him also, because he is also stated to be.
Lordship is my
Just a minute. Ma'am. Yes. Main person is this only, Rupjyoti. He is the main person.
Rupjyoti is the main person.
Anyways. Corporate. Please, home, learn it. Council and additional PB 483 bail application, Bosista PS case number 23 of 26. But another case is against him that is anyway, it's granting Dipen Sarma was arrested within bracket shown arrested in this case on 5/2/2026. The FIR was lodged by one Debojit Teka with the allegations that he had given in hire 3 vehicles to one Rupjyoti Das on rental basis, and subsequently there was a subsequently he was unable to communicate with the said person. Later, upon examining the GPS location of the vehicle, they were found to be in Borpeta, Itanagar, and another place in Borpeta. Full stop. It is alleged that the said Rupjyoti Das has misused the vehicles and illegally sold them to some gang. Full stop. The present petitioner is stated to be the owner of the firm
Fishery traders.
HRA Traders, and some of the vehicles were taken on rent on behalf of the said firm. Full stop. Full stop. The learned additional PP submits that there is no infirmity in the arrest memo as well as the notices. I perused the notices under 4748, which are in my opinion, which are bilingual in English and Assamese, and in my opinion, they are in reasonable detail to satisfy the requirement. The arrest memo bears the signature of the arrestee as well as one witness. Investigation has progressed. It is submitted by Mrs. Som Learned Counsel that the vehicles have been recovered. You found it?
That vehicle recovered,
Oh,
but
the vehicles mentioned in the FIR have been recovered.
but
However, on this,
some other vehicles.
but learned additional PP submits that though the same are recovered, but there are other vehicles which remain to be recovered. The said Rupjyoti Das is he's in custody now. He's arrested. The learned counsel for the petitioner also submits that that he had also given on hire his own near relative's vehicle to the said Rupjyoti Das, and he has committed illegal activities with regard to these vehicles as well, for which he has lodged case in the police station. The statement of the present accused is also recorded. From which it is revealed that he came into contact with the Rupjyoti Das, co-accused Rupjyoti Das, and on his projections, vehicles were given on his projections, entered into this business of taking vehicles on rent, and the said person Rupjyoti Das was to give him monthly rent. He has stated in his statement that some of the agreements entered into by Rupjyoti Das were signed by him, but some of the agreements were forced by the said Rupjyoti Das, and that he was completely unaware about that person / co-accused selling some of the vehicles. In the given facts and circumstances, perhaps the accused can be granted bail at this stage, subject, however, to suitable conditions. As prima facie, it appears that the alleged criminal activities were committed on the part of co-accused Rupjyoti Das. Accordingly, allowed to go on 50,000 with one security with the satisfaction of the concerned learned court. CGM Metro and subject to the conditions that he shall cooperate with remaining investigation to the extent necessary. He shall not hamper or tamper with evidence. He shall not commit any illegal activities. Violation of the bail conditions. Return back his debt.
And the
Bail petition stands disposed of.
There is not to sue.
Charge sheet has been submitted, Lordship. So kindly call for PCR, Lordship.
Is it?
Substitute, we don't know. We
Charge sheet
don't
is
have.
submitted, case number has been raised.
Then,
Is NDPS
He-
15
he-
oblique 12.
Yes. The case diary is stated to be not received. Mr. Rahman, learned counsel submits that he has definite information that investigation is completed, resulting in a charge sheet.
Yes.
Okay. And case has also been registered. Therefore, scanned TCR comprising case diary, charge sheet, and any other relevant documents
NDPS number
is hereby called for from the learned court below, pertaining to special case number
NDPS 15 oblique 26.
15/26, arising out of
Special judge.
Dhilai PS case number 59 of 26 from special judge, which district?
Special Judge Difuk. NDPS Difuk. Karbiang.
Karbi Anglong.
Yes.
The accused was arrested on 18/11/25. This is from Manipur. The
Yes.
accused 18/11/25. Yeah, date, take the date. First date. After 2 weeks or something.
24th maybe.
24.
LCR.
31.
LCR. Online.
After 2 weeks.
Today is 13. You want it on 26?
24th or
16.
Yes.
My lord, I have been shown arrested, my lord. In the original case, I have been granted bail, my lord.
But it was, you were shown arrested.
My lord, here in this case, I have been shown arrested.
Heroin.
I have been shown arrested on 12/2/2026, my lord. I have completed 31 days. Originally, I have been arrested on 31/12/2025. From the date of original arrest, my lord, 74 days, my lord.
No, not in this case.
In this case, my lord, 12, my lord.
12.
My lord, 31 days, my lord. My lord, so far as the FIR, my lord, there is no any specific allegation me against at all, my lord. FIR is at page number 12, my lord.
13 grams of suspected heroin.
15 grams of suspected heroin.
Heroin.
Those contrabands have been recovered from the possession of Shahadot Ali, not from me, my lord, from the premises of Shahadot Ali. My lord, relevant portion is at page number 14.
Sabot Ali. Then can we see the forwarding report of this
My lord.
or the grounds of arrest?
My lord, page number 17. My lord. Grounds of arrest, my lord. During the investigation,
Where 17?
my lord, page number 17, 17.
17.
During the investigation of Saigaon PS case number such and such, accused Shahadat Ali, from whose possession contraband drugs were recovered and subsequently tested positive, he revealed that he had purchased the recovered cannabis contrabands from one MD Abu Bakr, son of Aforesaid, village Bhalokabari, PS Saigaon district, Kamrup, Assam. That the disclosure made by the said accused person clearly reveals the active involvement of the Abu Bakr Siddiq in illicit trafficking of narcotic drugs, thereby attracting the offense punishable under section 29 of the NDPS Act. That there exists a reasonable apprehension that if the accused is not arrested, he may tamper with the evidences, influence of certain witnesses.
He has other cases also against him.
My lord,
He's a peddler.
in that case, no, my lord. So far as the FIR, my lord, there is no any specific allegation. There is no.
Oh, no. He was shown arrested in this.
My lord.
No, he was already on arrest.
My lord,
Some other
already
case.
in that case, he has been granted bail.
That is pertaining to NDPS.
My lord, pertaining to NDPS, my lord, 21B, my lord.
He statement. He regularly consuming drugs and he is a peddler. He sold it to Sadat.
nothing recovered from my conscious possession, my lord. So far as the section 29, my lord, no elements of section 29 attack at all, my lord. Yes, because, my lord, section 29 is clear, my lord. From beginning to ending, my lord. I should involve there, my lord.
Conspiracy.
So, my lord, so far as the judgment of Tufan Singh, my lord, court is, my lord.
No, just a minute. Just a minute. Abu Bakr, he was granted bail in this case.
My lord. In Saga case
After
number
52 days.
My lord, after 52 days.
Yeah, he consumes, it seems. Most small consumers are also small peddlers because this is how they realize the money. They have to have the rehabilitation, otherwise they will not be able to get out of this cycle. Anyway, actually, it's not just so
At any
justified.
condition, my lord, so further
Frankly speaking, it's not so justified. Still, apart from the statement of co-accused, what are the other materials against him?
His statement also, my lord.
One statement.
Corroborated that, my lord.
One statement.
One statement.
One statement.
At this stage, my lord, investigation.
Yeah, yeah, that is true. A Pramanic learned counsel for the petitioner and additional people invoking 483, Saigaon PS case number 34020. He was shown arrested in this case on 12/2/2026. Posted. The case arose out of an FIR dated 28/12/25. Where full stop. Based on information, a search operation was conducted, and inter alia suspected heroin weighing 13 grams.
My lord.
13 grams without containers was recovered from one.
Sahadat Ali.
Sahadat Ali. Sahadat Ali. Sahadat Ali, who was arrested. Also. Sahadat Ali was arrested. So based on the statement of the said co-accused, the present petitioner was shown arrested in this case. With regard to the other case, being Soigaon PS case number 1 of 26, also under NDPS Act. He has been granted bail by this court on 20/2026. BA 246 of 26. Investigation has progressed, but it's still continuing. Most of the material so far appears to be the statement of co-accused. However, from his own statement, it appears, though inadmissible, it is revealed that he has been consuming drugs as well as selling it, and that the said Sahadat had purchased the drug from him. Full stop. The contraband has been recovered and statements of witnesses, important witnesses have been examined, have been recorded. Full stop. In the facts and circumstances, allowed to go on 50,000. Okay, 4%, 50,000 with one security. 35,000 or 40,000, 35,000 with one security of the like amount to the satisfaction of the Amrup Amingaon, subject to the conditions that cooperate, hamper, temper. She shall not indulge in any activity of consuming or peddling narcotic drugs. Stop. Stop. Violation of the bail conditions would entail cancellation of the bail. I don't want to write it because it's in a way amounts to prejudging. But they tell him to go for rehabilitation. Otherwise, he will again fall into this. Tell me one more case. Tell him. Disposed of.
Item number 17, 18, along with one.
Three matters are there.
Well, these are arising out of the same FIR, Miller.
I see.
6 of the accused has been arrested, Miller, in connection with Miller dispute PS case number 114, Miller, and allegations against me, Miller. Your lordship will
Which
find.
one should I take up first?
Miller, 17, Miller, 17.
17.
17, Miller. Lordship may kindly,
Bedi Modi.
yes, Miller, your lordship may kindly take 15, page 15, the FIR, that is on the vernacular, Miller. It will be better if I go for in a vernacular, this type of translated copy, Miller.
Page 15.
Page 15, Miller. It has stated Honman, Miller. Your lordship got it? Miller?
Yes, go ahead.
Honman
Honman
Binito Division Agent, মই জনাব বিচাৰিছো যে মোৰ নাম ভিকি বসুমতাৰী, মই গুৱাহাটী জাপৰিগুৰি নিবাসী যোৱা ৰাতি প্ৰায় 26 চনৰ তাৰিখে প্ৰায় 11টা বজাত মই গণেশগুৰিত ভাত খাবলৈ আহিছিলো। মোৰ লগত এজন লগত ভাত খাই অৱস্থাত কোনো অচিনাকি বাহি মোৰ কিবা পিষ্টল নিচিনা সামগ্ৰীয়ে মোৰ আঘাত কৰে আৰু মোৰ গলৰ পৰা সোণৰ চেইনডাল উলিয়াই লৈ যায় আৰু মোৰ মূৰৰ পৰা বহুখিনি তেজ ওলায়। So that is basically there is a scuffle between two persons while having dinner, Milord, in Ganeshguri suddenly, and because of some this person also having under the influence of alcohol, Milord. Now, whatever it may be, Milord, basically it is registered under section, Milord, 126(2), Milord, that is a wrongful arresting, that is bailable, Milord. 109, Milord, attempt to murder, it cannot be a 109, Milord. Number second is 181, Milord, voluntary causing part or grievous act. These are, and Milord, 3094 is a robbery, Milord, regarding snatching of Milord gold chain, Milord. My respectful submission, if your lordship will kindly see, there is a scuffle, Milord. Now your lordship has to see whether, if there is an injury, Milord, whether the injury is a grievous injury or not. That is nothing more than that. That is more than that, Milord. And so for the robbery is concerned, that is also, Milord, that there is a scuffle, Milord. The question of recovery of chain or whatever it may be, Milord, attempt to murders doesn't attract, Milord. And so far, the only thing is, Milord, regarding 118, that is volunteering causing heart, grievous heart, Milord. Now, whether my learned friend is that he was called for, Milord. Now, whether he is whether it is that the injury, so far injury is concerned, Milord, so lordship kindly see the Malad injury, Malad sustained in the forehead, Malad, but lacerated injury, 3 inch by 1 inch, Malad, simple injury in nature, Malad, Malad, can the injury report. Total 7 persons were arrested, Malad, Malad, out of scuffle, Malad, but who actually hit? It's a Malad, lighter, pistol like.
It's a
lighter, like pistol.
And they were probably at least some of them were under the influence of alcohol also.
Alcohol also, Milord. That is right, Milord. Now, what we say is that
12:30 a.m.
that is arms act is not there, Milord. That is a lighter, Milord. Seems to be like a pistol, Milord. So there is a scuffle between regarding, Milord, having the dinner and under the influence of alcohol, it has happened. It's a simple market, Milord, and he's gone to such things. The injuries also, Milord, is not grievous.
All three were arrested in connection with the same case.
Item number 18, my client is the owner of a roadside stall, where the other accused.
What is his name? Amit Bhomik.
Item number, no, lordship, Tonush Sadda.
Amit Bhomik is item number 1, today's motion. 1 man Ajir. Oh, achha.
Now, my client, he is the owner of a stall where the other 3-4 accused was taking dinner. So after the scuffle, he intervened to stop the same, and at the very moment, police came and took him also.
Malad, what has happened, I'll tell you. Malad, he is the owner of that particular hotel where there's a mark scuffle, Malad. And he wants to Malad, intervene so that it will not go. So those who are in the hotel, Milord, everyone has been picked up. 15 days.
15 days.
No, whatever it may be, Milord, days doesn't come. But thing is this,
Well, whether my custodial detention is a marpit, my lord, custodial detention is not necessary at this place, my lord.
Heard, Mr. Learned Counsel, the question. You will make some submissions or I'll record your name.
Yes.
It's it.
So my submission is that I have not involved in the alleged incident. He is the roadside stall. In the night time, he has started the
Yours
stall.
is item number?
18 lakhs. Tonus Sarda.
Yes. Tonus, yes. His name is there.
Yes.
Sarda.
Yes.
My lord, I am a small submission, my lord. My name is Amit Bhumi, item 1. There is no recovery from my side.
Pistol. There's no pistol.
No pistol.
Firearm.
No, pistol.
Pistol is a lighter gun.
Lighter gun.
Lighter gun.
Not gun.
I don't know about that.
It's a lighter, my lord.
There is a light.
It's lighter, it looks like a gun.
Plastic lighter.
Key firearms goes there.
Anyway. No, just asking.
Yes.
Okay. No, sit down.
I'm sorry.
No. This poor PS case number so and so. The date of arrest is same.
It's on 27, everyone.
Accused was arrested on 27/2/2020. So, in like your FIR. Case arose out of an FIR dated 27/2/2026, lost by one Diki Basumatar, with the allegation that on the previous night around 11 p.m. he had come to Ganeshguri in Gauhati for dinner with his friend, and while taking dinner, some unknown persons hit him on a head with a pistol-like thing and snatched gold chain. This gold chain, whatever it is, recovered. There's no materials. With profuse bleeding from his head. The present petitioner was arrested during the investigation. And in the forwarding report, it is mentioned, the grounds of arrest has been mentioned. The case diary has been received. The learned additional PP submits that no firearm as such was recovered, and the alleged weapon of assault was some kind of a cigarette lighter shaped like a pistol. The medical report is available, which indicates laceration, injuries in the nature of laceration, and categorized as simple. Investigation, seen the progress of investigation. In the circumstances, in my considered view, petitioner can be granted bail at this stage. So 40,000 with one severity of the like amount, subject to the condition. Then cooperate investigation. If you have not if you have already recorded, cooperate, not hamper and shall not misuse their liberty to commit any illegal activities or any breach of peace or any offences. Return case there. Same
To
order.
the satisfaction of Planet Chief Judicial Mission Metro.
So for 18 lakhs, I pray for reducing the bail bond amount.
I have already, I don't give much amount as you've seen. I don't, how much I have given? 30,000 to make. 30,000 nowadays, any case cash doesn't have to be given. Only people. Khali, just 80 now. The submission, his submission, please record it because he is the owner of the stall. The petitioner is submitted to be the owner of the stall, and he is not involved in the alleged occurrence. And Tanush is a roadside.
Tanush is a roadside stall owner.
Now your client is. I mean, what was this? What was your submission?
The same group.
Anyway.
But another thing, I have been assisted by Mr. Ann Polita.
Sure, assist.
Obliged.
I'm obliged.
19.
Lordship, 483 application, Lordship. Very unfortunate petitioner. Lordship, before perusing the affair, I would request your Lordship to look into page 8, Lordship. Page 8.
Page 8.
Page 8 is the time given, time of occurrence, Lordship. 25/2/2026. Information received in the PS 3/2026 Lordship. Thereafter, Lordship, I'll place page 9, the gist of the affair, Lordship. Para 12, Lordship, at page 9.
Page 9?
Page 9, para 12. First information contents. It's there, Lordship.
Yes.
Para 12, Lordship. On 25/2/2026 at about 11:45 p.m., the complainant's vehicle bearing registration number so-and-so was lawfully transporting 21 cattle from Purobi Gokhala, Rongia to 9th Mile Bazar under valid court order so-and-so. Upon reaching near Greenwood Resort, the vehicle was intercepted by a group of persons traveling in another vehicle. The accused person forcibly stopped the vehicle, snatched the ignition key from the driver and physically assaulted him. They forcibly took 2,000 from the driver and also demanded 2 lakh for releasing the vehicle, despite producing vehicle verified documents relating to lawful transportation of cattle. The accused person continued intimidation and compelled the driver to abandon the vehicle and the threat and physical assault as per driver's statement. And identify the accused person. This all 4 person has been identified. Hemango Panging is the petitioner present. Petitioner here. The incident involves allegation of wrongful restraint, robbery, extortion, so and so, Lordship. And now, Lordship, this, according to this, Lordship, the incident occurred as per the projected story of the informant. The incident occurred on 25/2/2026. And now, Lordship will come to the affair that 3/3/2026 at page 12B, Lordship, my application. This affair was placed before the police station on 3/3. And earlier also from the details I have shown, Lordship. So after a lapse of 7 days, his affair has been placed before the dispute police station, containing that the driver has identified this person who demanded who snatched 2,000 and demanded and abandoned the vehicle, Lordship. That was my contention, Lordship, is that, Lordship. 25/2, definitely it was a road rage. It was a road rage incident, Lordship.
No, not exactly a road rage.
Yeah.
They were, intercepted for carrying cattle. And then demanded money, taking advantage of that. When they did not give, something was there. So, snatched away or whatever. That is as per the FIR.
As per the FIR, Lordship. But
this FIR was lost by whom? This
affair was subsequently by the vehicle's owner.
Okay.
Vehicle owner lost the affair, Lordship.
The earlier one was by Abdul Hussain, the driver.
No, Lordship.
Vehicle owner.
Vehicle owner. After a lapse of 7 days from the AD's date of incident, Lordship, they filed the affair on after expiry of the 7 days without explaining the delay, Lordship, which is very crucial in this sort of cases, Lordship. Delay has to be adequately explained, Lordship. After lapse of 7 days, as per them, 25/2 is the date of incident, and on 3/3 this affair has been lost. And Lordship, my specific instruction is that, Lordship, it was a case of road rage, Lordship. Since they were carrying cattle and there was difficulty in driving by the, of course, I have solely denied that I was not there on the date of incident, Lordship. The rest will be revealed from that.
As far as
Their self-style.
As per their statement, they have demanded money.
Demanded
money, but snatching of the 2,000 is not there, my lord, as per their statement.
We have a lot of chaos nowadays. Everyone become very unruly. Anyway.
My humble submission, Lordship, without
This kind of conduct is not good.
Yes, my lord.
He has himself admitted that now
the law in their hand, my lord.
a lot of people are taking law into the hands. Sorry, madam, you wanted. Please complete what you're saying. You were saying something.
Yes, Lordship. My contention, Lordship, this is absolutely a case of road rage incident. No snatching was there. Was Lordship some altercation with the driver because of the road rage behavior, Lordship. that part, no snatching was done by any of this petitioners. Nothing was demanded, Lordship. And assuming, Lordship, assuming, not admitting, and if it is assuming that how this driver, a random driver can identify all the person with phone number. This is completely a make-up story, Lordship. After 7 days, it has been projected, developed, Lordship. After third incident, Lordship. So may I say, unnecessarily being taken into custody, he's a family man, having minor children, Lordship, and brought up from a well-to-do family, Lordship. So may I pray, Lordship, already 11 days in custody. Lordship, with any condition.
He so learned counsel and additional people fixed up the 483 bill application. Dispute PS case 120. So and so. He was arrested on 3/3/2026. The allegation in the FIR dated 3/3/2026 is that on 25/2/2026 at around 11:45 p.m. the informant's vehicle AS25FC 8391 was lawfully carrying 21 cattle, and when they reached near Greenwood Resort, it was intercepted by the vehicle was intercepted by a group of persons in another vehicle who forcibly stopped the vehicle and physically assaulted him and took away rupees 2,000 from the driver, and also demanded 2 lakhs for releasing the vehicle. Full stop. Despite showing it is alleged that despite showing lawful documents, the accused persons continued the intimidation. So if the cattle has to be stopped, law enforcing authority is there. In fact, we all cannot become police. So then nothing will be left. Nothing, no order will be left in society. The Som Learned Council submits that it was a case of road rage, and the accused person has not the allegations against the accused person is highly exaggerated and distorted. Full stop. It is also submitted that the FIR was lodged after a delay of 7 days without adequate explanation. The case diary has been received. This investigation has there's some investigation, including the statements of the accused persons. The present petitioner in his statement has admitted that he has earlier also involved in interception of cattle carrying vehicle. Full stop. But he denied that he forcibly took away any money or assaulted the driver. Frankly speaking, it's not anyway. He was arrested on 3. Not much. In the given facts and circumstances, I allow this bail petition subject, however, to suitable conditions. Accordingly, 30,000 with 1 security. Subject to the condition number 1, he shall cooperate with remaining investigation, not hamper or temper. He shall not misuse his liberty to commit any illegal activities or offences, including any activities or offences alleged in the present case. In case of violation of the bail conditions, his bail would be liable to be cancelled. Cancel forthwith. Return back the case diary. Bail petition is disposed of.
And deep W.
22.
Wait, please, my lord. My lord, today is 93 days, my lord, since the filing of the. My lord, CD has not come, nothing has happened, my lord. There is no progress, my lord.
Interim is there, no?
Interim is there, my lord. It
CD
won't
has
be
come?
made absolute.
CD not received, my lord.
My lord, may I kindly.
Depends on the, okay, what kind of case is there?
Yes, my lord. May I kindly demonstrate, my lord?
Kind of ransom, yes. Let me-
My lord, in this case, my lord, what had happened is that, my lord, we are not the FIR named accused. We are two applicants, my lord.
Hmm.
What had happened is that, my lord has page 13, my lord, of the FIR. My lord, few persons had apprehended, my lord, the Ajaharkari on the pretext that he's into the drugs business, my lord.
Hmm.
And my lord, when those persons had apprehended the said Ajaharkari, we were passing through that area.
Hmm.
And my lord, generally happens in, my lord, relatively smaller places that everyone asks what has happened and things like that. We had also asked, my lord, because we were in our scooty and we had asked. Thereafter, my lord, that much, my lord. We had left immediately. We were also going for a medical treatment.
Hmm.
We went, my lord. Medical certificates also have appended. So, my lord, that is the sum and substance of the case, my lord. We are neither the FIR named accused nor we were involved in the case, my lord. We approached this honorable court because, my lord, that is the case, my
Yeah,
lord.
anyway, I think we should.
Short date, my
Sure,
lord. Short
yes, Dari.
accommodation, my lord.
93rd day, my lord. I am entitled, my lord. Anyways.
93rd,
Interim protection
you're not
is there,
arrested, no?
Not
Interim protection is
93rd date in what sense? 93 days?
filing of the case, man.
We don't have that instruction.
It's our duty actually to dispose it off. In 93 days, it should not remain pending.
Anticipatory
That is
bail
the-
application, my
that is
lord.
The case diary is not yet received. Learned counsel praised for making the bail absolute. However, the prosecution shall endeavor to procure the case diary on the next day.
Right.
Full stop. So you get the case diary.
Interim passed earlier.
Interim shall continue.
Date, short date.
19th, my lord.
19.
19.
19-3. 19-3.
19-3.
23. I'm obliged, ma'am.
Really, no, this was not a short break. No? Daily was a short break. Yeah.
My lord, CD is not received.
CD is not received.
CD not received, my lord.
Okay.
My lord, interim may continue.
Yeah. Don't worry. That will be done. Case diary not received. Issue reminder. Interim bail granted by the order dated 12/12. 12/12. Stands extended till the next date of listing.
Bless me.
No, take the date, please, madam. Take that. I forgot. Huh? 20. Huh? 20. 20th March.
25.
Before lordship.
Mhm.
Here is their lordship. Allegation section lordship 45. Here there are 3 subclass 2 lordship, student lordship, FIR at the 7 lordship.
Just one minute. What happened? Well, he lost his motorcycle, the informant.
Yes, lordship. And lordship, the 2 person has been arrested forwarding with the lordship at the same lordship. One is Habibur Rahman, Sainur Islam. Habibur Rahman is my friend. That's why police has been searching and visiting my house lordship.
No, 2 persons were arrested.
Arrested.
Huh? Habibur Rahman and huh?
Habibur Rahman is my friend.
Oh, Sainur Islam.
Sainur, one is Habibur Rahman.
Let us see the FIR. The diary has come.
Come, my lord.
You see, it's,
Yes, my lord. My lord, I kindly tell you, my lord. The diary, along with the my lord, they have my lord categorically my lord paid of fiction prayer, along with the statements, my lord, released. Here, my lord, the case is this, my lord, the informal lodge and FIR, my lord. The parties that, my lord, he said that, my lord, that was stolen, my lord. But, my lord, during the course of investigations and when, my lord, their, my lord, statement recorded, it comes, my lord, it was not stolen. My lord, the bike was given to another person stating that it is a, my lord, it is stolen.
to take the advantage of the my lord, that is an insurance company. Now, my lord, this is a syndicate, my lord, not the one person, my lord. That is the my lord, apprehended person, Habibur, my lord. Now, along with that, my lord, the main person is another person is my lord, Shahinur Ali, my lord, which is before your lordship today, my lord. It is an access, my lord, and not only one person, my lord. This way, my lord, my lord, first they take from the finance, my lord, take a my lord vehicle, then thereafter they lodge an FIR that my lord, it was stolen, my lord, take the advantage of that, my lord, and again, my lord, that was sold, my lord. My lord, may I kindly produce, my lord. It is, my lord, very less.
vehicle is
Stage,
not
my lord,
recovered.
still, my lord, the things need to, my
Vehicle
lord,
was not recovered.
more investigations, my lord.
Vehicle was not recovered.
It was it was a racket.
My lord, may I kindly produce the first, my lord, the informant statement, my lord. I have flag mark, my lord, everything, my lord. And also, my lord, that is the objection prayer is there, my lord. That is also I have flag mark, my lord, from the end of the as well.
The present petitioner's name is Shahinur Ali. So that the FIR was false. False FIR.
All syndicate. The entire thing is, my lord.
Lordship, the vehicle is not recovered.
And the vehicle has not been recovered also.
Recovered, Lordship.
Actually, the dealer was cheated.
Am I?
The main
Right.
victim is him
The
actually.
new kind of, my lord, these are the, my lord, crimes.
All kinds of things will happen now. Ethics are destroyed. Anyway, Mr. Das, learned counsel for the petitioner, and K. Boysa, learned additional people. 482 bail application, taking bail for Shahinur Ali in connection with Rangjuli PS case number 40 of 2025 under so-and-so section. The case arose out of an FIR dated 25/10/25 lodged by Shahinur Islam with the allegation that on 19/10/25 in the morning he parked his motorcycle AS25AA4187 near the newly constructed building of Rabha Assam and proceeded for some work, but after returning at noon, he found it missing, and despite searching, could not find it. The two persons were arrested during investigation, including the informant, and namely the informant and the one Habibur Rahman. It is submitted by the petitioner that and the petitioner is the friend of the said Habibur Rahman, and therefore police are looking for him, causing him apprehension. of arrest and hence this petition. Full stop. Case diary has been received along with a bail objection. Full stop. The iOS stated and contended that the FIR was actually a false FIR, which was part of a conspiracy involving these accused persons, including the informant and the arrested persons, about taking of a motorcycle from a dealer on payment, on down payment, an EMI. Full stop. And misappropriating the same. Full stop. It is stated that the motorcycle is yet to be recovered. The IO objects to the grant of bail. The learned additional PP has drawn my attention to the statement of the informant and also that of the co-accused. Considering the nature of the materials revealed, it may not be prudent to grant anticipatory bail at this stage in the interest of effective investigation into the matter. First, according the bail petition stands rejected at this stage. Return back the case study. Okay. Yes.
26.
Maybe Lord.
Hmm.
Perhaps CD has not been received, Lordship, but my submission will be defined, Lordship, on law point, Lordship.
Better, my lord, first submitted, my lord. We have a communication.
21 is bailable offense, I think.
Lordship, I have some order of this for the independence of this court, Lordship. For similarly,
You don't need an anticipatory bail, actually, in a sense.
then-
Give me that order.
Lordship.
Charge sheet is also submitted.
Lordship, para 22, Lordship, some protection may be given. I will appear before the IO. Para 23, last page, Lordship.
Yeah, that's correct. You can you appear before the IO
Lordship, yes.
or before the court. No, isn't it? Before the court can allow you to go.
Lordship, that may be.
Right. Mr. Heard, Mr.
R. Islam.
R. Islam, learned counsel for the petition. And gave us an additional pick. 482 bail application and so and so. 21 small a.
Yes, Lord.
The and 29 NDPS Act. So Dhubdhara PS case number 4 of 26. Full stop. The learned counsel has placed a decision of this court rendered on 3/1/25 in AB 3029 of 25. Noticing that section 21A of the NDPS Act pertains to a bailable offense and bailable offense. Full stop. There was another judgment actually where it was an observation was made earlier.
Alia Lordship 2020, Lordship.
Mr. Anyway, so, learned additional PP submits that investigation is completed in the meantime, resulting in a charge sheet. Full stop. Charge sheet is under which section?
Yeah. That communication may be taken as a part of the record.
By its CS number 11 of 2026. Stop. Considering the fact that the penal provision in question section 21A and the NDPS Act is a bailable offense Therefore, the anticipatory bail, which lies only against non-bailable offences, would not lie here. However, the petitioner would be entitled to get bail as a matter of right, as the offence in question, that is 21A, is a bailable offence. In such view of the matter, IO, since charge is there before the court only. In such view of the matter, the bail petition is disposed of with the observation that the petitioner may appear before the learned court below and prefer a bail application, which shall be pray for regular bail, which shall be disposed of as per law, keeping in mind the aforesaid observations. That's all. Can I keep this one? You can take it back. Waste your thing. This will remain. It lie on it. Take a short break. We'll done.
Time being at 11.
11. What's this one?
Initially registered under section, my lord, section 6 POCSO, read and 65.
Withdraw this case. Lordship, but till date they failed. Lordship. And Lordship, in this case, Lordship, its notifications, it's completely covered, Lordship. Can you see this notifications, Lordship?
26.
Page 26, Lordship. Lordship, here it is mentions, Lordship, last word regulations raised, Lordship. Pursuant to this cabinet decision dated so, it has been decided to go for withdrawal the cases under so, where punishment is up to 3 years or fine or both under this Indian Penal or other special act or Lordship / regulations.
Yes.
Lordship. So here my case is registered under.
The main thing is up to 3 years.
3 years. So here this
except this.
Except this, Lordship. So my case is not falls within this exceptions, Lordship. And Lordship, thereafter, Lordship, what happened, Lordship, there's similar cases. Lordship, that is page, kindly see page 31, Lordship. The 31, this is the offense report, and Lordship, page 34. Here, Lordship, 34, that case has been withdrawn. Lordship, that case has been withdrawn. So ultimately, case 35, Lordship, case 35, this Honorable High Court has directed to release this vehicle, Lordship. Similar situated persons, Lordship.
I'll study
Lordship. So ultimately, Lordship, thereafter, Lordship, this petitioner has submitted these representations to consider this case, but they did not take any actions. So, Lordship, that's why present petitioners has come before this Honorable Court. Lordship, there is, Lordship, I have initially I have told I have two-fold submissions. First, Lordship, if there is often prosecution is there, then Lordship, my submission is, Lordship, one judgment I have submitted earlier in the apex court judgment.
Apex court?
Yes, Lordship. In this apex court, what has said, Lordship?
In the other submitted in the other case, not finding any apex court judgment here. You have annexed judgment of this court.
No, Lordship, I have a loose copy. I have annexed. Has it given, Lordship? There is a ground has been given several ground, Lordship, for washing. There is one ground is showing, Lordship, if long delay of for an investigation it is also a ground, Lordship. So here in my case, Lordship, it is not heinous crime, Lordship. It is a petty offence. 8 years has gone. So, Lordship, is the pursuant to the apex court judgment, Lordship, my prosecution, whatever prosecution, Lordship, that may be quashed, and when after quashed, Lordship, my vehicle should be released, Lordship. That is the one submission, Lordship. And Lordship, if Lordship,
yes,
and if there is Lordship, there may not be prosecutions, Lordship. If not, Lordship, until date, Lordship, they are not unable to submit before this honorable court any instructions whether any prosecution case is pending or not, Lordship. Kindly peruse, Lordship, this order sheet. From the beginning, this honorable court has repeatedly directed to submit the instructions whether any case is pending or any why this case has not been withdrawn, Lordship. So, Lordship, that is my second submission. Lordship, now Lordship kindly come into, I have submitted one more judgment, Lordship, of our High Courts. Lordship, it also on record, Lordship.
Yes, that I've seen.
Lordship, in this is the this case and in my present case is completely covered. Completely cover up case, Lordship. Here in this case also same incident, Lordship, 8 years has gone. 8 years has gone. No convictions was taken place, Lordship. Lordship, kindly peruse this order, Lordship, paragraph number 17.
Do you have the copy of that Supreme Court order regarding that interim which was dismissed? You have. Let me keep that for safety. In this judgment of 9-6, which para should I see?
Lordship,
which you have annexed. It ends with para 13 actually. Para 12, it's the typing mistake.
My lord, the High Court case also, before going to Supreme Court, that judgment is also I have.
Which one? This one? Which
yes.
he has annexed?
Yes. No, it is not annexed, my lord. Only the other part is annexed. The original case, my lord, is that then again went to Supreme Court, which also, my lord, I have handed the copies.
Deep Kumar, that case has been that vehicles has been released, Lordship, by this honorable court's order, Lordship. That order I have annexed, Lordship.
But my lord,
let me come.
I can reserve it also, and if I run into some doubt, I can again get it listed for to be spoken to.
Lordship, kindly,
that option is
that, Lordship, kindly peruse my this High Court order, Lordship. I have it's on the record, Lordship. I have
yes. Which para?
Lordship, paragraph.
Or we'll keep it for something like Friday, because I have division bench next week. I may have single bench also after rising of division bench, but I don't know. But division bench is still Thursday, till Thursday. Till Thursday. So Friday, I think I'll be single.
May I pay 23rd, my lord, Monday, the next Monday, my lord.
We'll work it out. Yeah. Which para?
Lordship, case para number 17, 18, 19, 20, 21. Lordship, this judgment is completely covered.
You have annexed this?
No, Lordship, I have loose copy has been.
Loose copy. No, I don't have. What is the name of the judgment?
Lordship.
Gaurav Pandey. Gaurav Pandey is still para 12 that you have annexed.
No, Lordship. No, Lordship. That is a repetition 6690/2005, Lordship.
No, it's not here. If you don't have a spare copy, I'll have a look and give it back to you. Give it. That will add one. Which is the operative paragraph?
Lordship, I have.
No.
Yes,
I will see it and give it back to you. You have marked. Two 2005 decision. Go. Yes, this is the thing, that though this word provisional confiscation is this word has been held to be a misnomer, because it will be confiscated only after guilt. Otherwise it will be a violation of due process.
Lordship.
Otherwise, so it is actually seizure of property which is liable to confiscation.
Lordship.
Right? This is what has been said. Very correct.
One more thing, I heard some provisions.
Just 2 minutes. Confiscation. Yes. So it is like a Jimma. This is like a seizure.
Seizure, yes.
You forget about the word confiscation.
Yes,
seizure, that property is liable to confiscation. Any property subject to crime is liable for confiscation.
Lordship,
actually.
Lordship.
We can write it in the,
Lordship.
it will be
Yeah.
confiscated to the
Lordship.
state.
But here in this case, Lordship, also it is a mentions. So 51 is deals to convictions. This property will be confiscated after convictions, Lordship. But in that case, Lordship, no convictions, no investigation has been completed, Lordship.
That you are not aware, no? Whether it is, what is the stage of the case? Trial?
That, my lord, I will have to take
One
instruction, my lord.
That, I
Because
think,
the offender is absconding, my lord. Because petitioner is not the offender. He was not found.
he is
at
the owner
spot.
of the vehicle.
Owner of the vehicle, my lord.
But he, if other things being equal, he should not suffer.
Lordship,
Isn't it? If ultimately he is also found guilty, then it will be liable to be confiscated.
Lordship.
Standard of mens rea in this situation is that he should not have had the knowledge, my lord, that his vehicle was used.
Yes, that is the thing. He should not have the knowledge. Otherwise, too, it will be very dangerous. Nobody will be able to do transport business.
Lordship.
That is also there.
Lordship, in this case,
What is this? You committed.
Yes, I sir. Lordship, what happened, Lordship? During this pendency of this case, Lordship, the Forest Department has issued this notice. And this notice is saying, Lordship, you come and take your vehicles, Lordship. And ultimately, Lordship, the petitioner has a
You have a copy.
Lordship, what happened in this case, Lordship? The Forest Department, Lordship, DFO, concerned DFO. Today's my instruction is also that, Lordship. They are not opposing, as because pursuant to this letter, Lordship, they are saying you come and take your vehicle. And when they appear, they are saying that, Lordship, that one case is pending, so you can approach, you can pursue this case. We are not opposing. So and this letter also saying same thing, Lordship. But why, Lordship, my learned friend is opposing?
You are only concerned that, my lord, it should not, my lord, become a precedent for others to, my
You
lord.
take a instruction regarding the stage of the trial. You know, I'm keeping it part third. You know, your effort will not be wasted. I've understood. You know, in the meantime, I'll study. And next day, I'll be in a better position to understand your submissions.
One more thing, Lordship.
Remaining submissions.
One more thing, Lordship.
Tell me.
Lordship, my learned several times, Lordship, kindly peruse several date. They are same.
Please take on the next day. Don't fail.
I'll take it to logical conclusion.
Okay.
I'll not.
I've faith on you. We'll sort it out. We'll dispose of this matter. Don't worry. This much I can assure you. Which way we'll go, and nobody can say, of course. So, you want it on 23rd?
23rd.
I'm here. That's
If possible, Lordship.
Bench, I don't know, but I'm here.
26. If possible.
26. That's not a problem. You had thought you wanted earlier.
Only next
So,
week, my lord.
heard learned counsel, so and so. Addition matter. Mr. Hawk, learned counsel for the petitioner. And I Bothapur, learned counsel representing the Forest Department with regard to forest offences. Though arguments are addressed by both the learned counsel for both the sides, but the same is not concluded. The concluded. The respondent, the learned counsel for the forest is directed to take instructions regarding the stage of the trial, if any, in this case.
Oh, my lord, any confiscation proceeding with respect to the vehicle.
Or any confiscation proceedings which are still going on with regard to the vehicle in question. Full stop. You want a copy of this order? I have not written anything. That's okay, no problem.
Yes, sir.
Keep the matters part third, list on 26. Okay.
Lordship, one more thing, Lordship. In the next date, Lordship, my friend, one observation may be given, Lordship. That on the next date, my friend, if fail, Lordship.
No, those things I told you, no? Those things are I'll remember it. You know, from my experience, I'm telling you, these things are actually counterproductive.
Not be, my lord.
Counterproductive, and sometimes anything happens that it is not possible, suppose, and he can get it within two more days. Then you will be bound by your own things. You know?
Other judgments that are annexed, my lord, I was there in those proceedings. When concession was required, I had given, my lord.
No problem, and I'm keeping it as part third. So this exercise will
Lordship,
not.
Otherwise, Lordship,
This exercise of yours and mine will not be wasted.
So I am submitting one thing, Lordship. The department, there is since back, Lordship, repeatedly this code has given directions.
No, they should also be very fair. That's okay. But please take care. Huh?
I'll take care.
Please take care.